Next item is mock complaint overview and hearing.
So this is what you guys requested a few months ago, is to do a mock complaint, kind of more for the public too, to walk through. I can't remember when this was requested, maybe January or February, or was it even November?
It was originally a discussion when we were talking about 1360 and a new process. What would that look like?
Yeah.
Well, now we're reverting to the complaint process at the commission's request to do this mock problem. I'll note that we did not have time to adapt the new changes in Senate Bill 2004. So I'll just note them as we go through it. But that's where we are.
So basically then it's still an ongoing project.
No,
No,
it's
it's
ready
ready.
to do.
Oh.
It's ready to do. We just didn't modify it since
Oh, so it's just.
Friday afternoon.
Modified yet, okay.
We don't plan on modifying it either, Dave.
Okay, fine.
Have Alicia bring it up.
So how do we, how should we proceed from here for the mock complaint overview and hearing?
So my suggestion would be to walk through the problem itself, just to give an overview of the problem. And we could do not a full-blown mock hearing, but just a general outline of what a hearing.
Kind of a
would look
tabletop
like.
discussion?
Yeah, and how
Okay.
the procedure and how we walk through it.
I like those.
What do you call this in the military where you
Tabletop.
is that what it is?
Yep.
Okay. I thought there was a cooler definition for it. You guys have lots of cool definitions for stuff. I was expecting a good one.
We just called it mock complaint because
Yeah.
we call it mock trial in law school.
We aren't very creative.
Okay,
So you have the problem there, a problem overview. We tried to make it sound fake because it is fake. So we created a fictional department and public official in state government. So it is now the North Dakota Department of Forest Creation. The idea here is that it will show you as commissioners, but more importantly, the public, since the complaints are confidential, an overview of the whole process from receipt to complaint resolution. So we did that. This document, the first document you have, is kind of like a mini report and recommendation, so the public is aware what those look like when a complaint investigation is over. But we've also created sample documents throughout for how what we receive as commission staff, what the commission receives at certain stages in the process, just so we can demonstrate those as well for the public's benefit. So again, we created a fictional public official in office. It's all tree related. We thought it was kind of fun. So
Do you want to emphasize where a lot of this material came from? Because this was.
yes, a lot of this was created with ChatGPT because we keep talking about how our time is valuable. So we use ChatGPT to draft some of it substantially and create these fake facts. So again, disclaimer, it is not real, and any resemblance to anything real is coincidental because it was made with ChatGPT. So there were 4 things that we wanted to highlight that come up during the complaint process. One would be a required criminal referral. Now with Senate Bill 2004, we know that's discretionary, so just keep that in mind. If it's signed into law, I always need to caveat that we don't know where it's at right now. 2, informal resolution. 3, an uncooperative witness / lack of that clear subpoena process that we just discussed. And then 4, a potential conflict of interest for a commissioner / staff, because that can diminish the commission's resource if there's a recusal or a potential conflict that just comes up in the process itself. So again, following this title page, it's just a abbreviated version of a report and recommendation what the commission receives at the end of an investigation. Real reports and recommendations will reference the investigation file and the underlying documents / evidence that's found during an investigation that the commission also receives and the respondent receives before that final hearing. So again, we made it in summary form and we annotated quite a bit of it to save time, but it explains what's omitted and why and what it would do. Yeah, and then throughout there's some footnotes to the sample documents which are attached to the problem as examples. So if we go to the next page, I'm just going to walk through the report here. So
Do you want to start with the complaint that we would have received, or do you want to start with this?
yeah, why don't we go to the attachments, Alicia?
There you go.
So we created a mock complaint so you can see what it looks like when we receive it in the office. So this is what it looks like when somebody fills it out on our website. We receive a PDF of it. They put their contact information there. It does two things. One, it tells us who filed it so we can contact them, but also if they meet the requirements to be a complainant, whether they're a North Dakota resident or the other two things that they're licensed in North Dakota or they're subject to a quasi-judicial proceeding in the state. And then the complaint details come after that, who it's against, their job title, the date of the alleged violations, and then a description. So this is the most important part, obviously, of the complaint, the allegations. But when you have a citizen who, it's usually not an attorney, usually not assisted by an attorney, the allegations in a complaint are very minimal sometimes, or sometimes there's a lot of words, but there's not really much to what's presented in the complaint. So going through it and trying to figure out what actually is there can be challenging when doing that initial review. But here it's a really simple one, 2 paragraphs, not really even 2 paragraphs, but they're saying Director Oak Ridge oversees a legislatively enacted program to plant trees and create new forests in North Dakota. He owns the Giving Tree Company, which made a lot of money on the program, and then they say that's a conflict of interest. And then there's an allegation of bribery, that he bribed this legislator to bring the bill in the legislature in the first place. So this, again, we made this, so it kind of gets to the crux of the issue, but there's bribery and conflicts of interest allegations in the sample complaint. So then if we scroll down, then we get to the confidentiality designation for the public official, or for the complainant, excuse me. And this complainant, John Mistletoe, he chose to keep his name and address confidential.
Did you make up the names or did?
ChatGPT did a lot of it.
Okay.
I made up where he was from. Did you see that? He's from Oaks.
Oh,
That one we could find. That
It was tree related. So.
yeah, great.
So Mr. Mistletoe just chose to remain confidential. So that'll come back later in the process. So we received that complaint. Again, the commission's well aware step 1 is the initial review. So we as staff do the initial review completion report. Once that is done, get there. So here is our form that we use in the office. Again, it's a checkbox form. It's made to be straightforward so that the commission can review these easily when it comes time for a meeting. But it's split up into 2 things, really. Personal jurisdiction. Does the commission have jurisdiction over this person? Yes, check a box and explain. This one, he's a public official. He's an appointed official in the Department of Forest Maintenance or Creation. It got changed a couple times, so things aren't consistent. Please excuse them. Then we have the subject matter jurisdiction box. Again, this was a conflict of interest, so that's within the commission's rules, but also it references a bribery allegation. And then, as you can see there, there's 2 statutes cited for potential violations. So that means that during the initial review, commission staff actually found a different statute that may also apply, and then corroborated them by publicly available information. So then there's an explanation box if we scroll down, or there's requires more information. So this is what we'll do usually in a initial review, provide the commission with more information on why the recommendation that's above is being made. So again, here we have the current statute that requires the commission to criminally refer matters when the commission believes the complaint contains allegations of criminal conduct. In this fact pattern, we were able to corroborate that the contract shows it was signed by the state with the Giving Tree Company, which is Mr. Oakbridge's company, as shown on his statement of interest that he filed with the Secretary of State. And then based on that, commission staff also requested that legislator's statement of interest for the fact pattern, which also showed he had an interest in that same company. So there was some corroborating effort done before it is recommended that the commission refer it to law enforcement. So then that's, the boxes are a little out of order, but number 3 is next steps. And you can see that the further review will pause until the commission has the opportunity to discuss a potential criminal referral. So that then goes to the commission at the next meeting for the commission to discuss in executive session.
So we're well aware that you guys have seen these forms many, many, many times, but the public has never seen a form like this. Hence why we included these so that they could see what we are doing internally when we review these complaints during that initial review stage.
So again, just following the fact pattern here that we created, let's assume that the commission did refer it to law enforcement. Again, this would be the state's attorney with jurisdiction. That's in the sample report and recommendation that that's what happened. And there was a prosecution that resulted in a plea agreement. If you want to read the fake details, they are in the fake report. But then after that, the commission receives it back. After the prosecution happens, the commission receives it back. So we need to reevaluate, okay, what stage were we at in the process? Well, initial review was completed. So under this fact pattern, you move into informal resolution. And that's when both the complainant and the respondent receive our standardized informal resolution request form. So it goes out to them with the complaint number already filled in, and then they need to check a box and provide the commission with some information on whether they want to engage in that process or not, and how best we can accommodate them. But then if you'll scroll to the next page, Alicia, please. After the accommodation questions, number 4 really gets to the crux of the issue. What do they believe a reasonable resolution of the complaint would be? And usually we will get something back like this sample one said. You need to pay back all his money as well as resign from his position. And maybe in this fake instance, this is a reasonable resolution. Who knows? Again, it's fake. I can't emphasize that enough. He needs to resign. It's what they're requesting.
We're not really trying to create a forest creation program.
Any questions at this point? You're all well versed in that stuff.
So this has all been done independent of a hearing?
Yes.
Yeah, we're not at the hearing yet.
This
Yep.
is all the process before we even get to that hearing.
Get to
The
that
hearing's
point,
at the
okay.
very end.
Okay.
So in the,
One second. So did you get to the informal? You already did this,
I
right?
just want to.
Okay,
Yeah.
yep. So this is again a form, you guys don't see this usually, the informal resolution, but this is what we electronically have them do. So that's another good one for the public to see as well as the commission.
And that really only goes to us as staff who's trying to mediate the complaint. We do not exchange them with, like, the complainant does not see the respondent's informal resolution form, because then they know the background and the details of what is going on. And usually you'll see that with a lot of mediations in the court system, that they won't exchange those statements because it's for the benefit of the mediator, which in this instance, it's us staff trying to mediate the complaint. So I need to check the facts here just so. So I think here with informal resolution, the facts we came up with, which is a common occurrence, is that both the complainant and the respondent agreed to engage in informal resolution and they negotiate in good faith, because most of the time they do, they're just very far apart and sometimes their expectations are not realistic. And you have the added caveat of the complainant in this case is confidential, so we can't bring them into a room to have a conference. We have to go back and forth with somebody. Usually if they're a confidential complainant, it's phone calls to that person to get their position, and then communicating those to the respondent, getting maybe a counter offer and taking that back and forth. So again, in most instances that can go on for some time. Here we said it went back and forth for about a month, because that realistically occurs quite often. But then it becomes very clear at some point that they're never going to come together and reach a resolution. So one of them has to say, well, I'm done. I'd rather proceed to an investigation. Then at that time, the commission can move the complaint into an investigation. Now with the amendments to 2004, we move it to a different process where the commission can negotiate to settle the complaint instead of moving it into an investigation right away. But here we're operating on the current law, so we'll continue to the investigation. And at that stage, the respondent will receive a form letter like this from myself that says, we are notifying you that the investigation has begun pursuant to the laws that authorize said investigation. Again, we explain that it happens when they're not informally resolved. This will obviously change with the new amendments to the law, but then it gives an outline of how the investigation proceeds. It's by the executive director and commission staff. The commission ultimately makes the determination. Again, then the confidentiality piece, but they are notified at each step in the process of where things are at. We just didn't include the other earlier letters, just for the record, because this gets quite lengthy. So let's say we go through the investigation. The executive director then, with the assistance of staff, prepares the report and recommendation for the respondent. Once that is done, we will meet with the respondent and go over the pre-hearing acknowledgement and stipulation, which lays out how they will receive the report, how they will receive the investigation file, which becomes the record, informs them how to submit their response to said report in person and in writing. The statute says they have a or. The stipulation allows them to do both. I think the commission prefers that they do both, so they have as much information as possible to make that decision. And then it outlines the commission meeting and the hearing on complaints. So again, this is from Century Code and from the commission's rules on how this operates, but that they'll meet in executive session because complaints are confidential. The meeting is audio recorded, or it can be video recorded, depending on how the commission sets it up. If they need accommodations, please contact the commission, and then the commission will conduct a hearing at that meeting and outlines the procedure for how that happens, with the chair or the chair's designee determining the order of presentations and the time allotted. So when we were developing this form for pre-hearing acknowledgement and stipulation, it was kind of not clear. The statute doesn't provide a process. The rules don't necessarily provide a process on how much time is the default, or what does that look like. So it's, again, modeled after a bit of court procedure. This one specifically really the Supreme Court, but again, the initial person, the executive director and staff get 30 minutes, then the respondent responds in the 45 minutes, and then there's 15 minutes for rebuttal, essentially. In practice, will this time be needed? Probably not. That amount of time won't probably be used by us as staff or the respondent, but it's allotted just in case, so they can, each side can essentially make its case regarding the complaint. And then once that hearing is done, the 5 commissioners meet in executive session outside the presence of anybody on staff who assisted with the investigation, outside the presence of the respondent, any witnesses, their attorney, etc. It's just the five of you who deliberate and consider the record, the report and recommendation, the hearing, any response provided by the respondent. And then the commission makes its decision during those deliberations and informs the staff and the respondent of its decision.
So the commission will have to, in effect, designate a secretary in case they're going to amend the proposed order, because the staff will not be available. Technically.
Correct.
That is correct.
You want to type this?
Yes, take a break.
Okay,
Starting with you, Ron.
What's that?
So let's all return to court 2. 10-minute break. That's a very complete.
So we went over the stipulation, which is attachment 5. So then you'll see here attachment 6. Once that stipulation and acknowledgement is signed, then it is communicated to the chair, who then finds time to set a hearing. And usually it'll be during a regularly scheduled commission meeting, or maybe a special meeting will be set. There'll be one already occurring, but the order setting hearing is then signed by the chair, and it'll give the presentation time and the date and time for the hearing. So like today, let's take 1:30 where we're at. So that is the documents that set up the final hearing, and then the commission, the 5 commissioners, will start reviewing the report and recommendation. The respondent will review it and craft any response the respondent wishes to provide. You go back to the top, Richard.
Very, very top.
Very top.
Oh,
That's
this
the
one?
last document.
Big one?
Page 2. So this is this is the part of the problem that really shows what a report and recommendation will look like. At the top there, we make a note that a real one will have a cover page and the table of contents, but then it breaks down the investigation in summary form, so you can reference that here. Again, the conclusion, but we can get into that for the hearing part. Go to the next page.
I have a question.
Sure.
On page 1, order setting hearing, you've got presentation time, executive director, initial 30 minutes. Oh, and then the rebuttal after the respondent. Yeah, okay, I misunderstood. I understand now.
It's
Go ahead.
equal time for both.
Yeah.
So then in the report and recommendation, again, we reference that there will be footnotes, many footnotes included in a real one, and then the underlying investigation documents or files, whether they're recordings from interviews or paper records that we've obtained, etc. But it'll go through an introduction, a factual background, that includes the initial review, any criminal referral. Again, this is all made up for purposes of demonstration. Informal resolution, and then it'll break down the investigation. So here's really where ChatGPT took over and identified 6 witnesses that give little synopsis of the interview with each witness, which follows what we would do in a real one. Then it'll break down the ethics laws that apply to the complaint and the commission's review of the complaint. And there'll be a background on the commission's authority and its investigations. And then after that, the subsequent law that applies for the conduct. Then the report and recommendation will actually analyze the facts that were found during the investigation, and it will lay out any proposed ethical violations if there are some. Here there's 3. It'll describe any aggravating and mitigating factors, complications from the investigation, and then recommendations for resolution for the commission, which is usually in the form of, we recommend you adopt a proposed order, which is attached to the report itself. What are the last 2 pages? It will look like that. It looks similar to court documents. Again, this is within the commission's internal process, but it'll lay out things. And then if the commission makes a decision to follow the executive director's recommendation without changing the report, it's prepared so the chair can sign it if that's what the commission chooses to do. But the commission can also change it if there's certain things that occur during deliberations. If you need a copy of it, staff can get that to you so you can make those changes. And then again, once the chair signs it, that kind of concludes it for the commission's purposes. A respondent can appeal that if there's a finding of an ethical violation. If they do, they have 30 days under the commission's rule. If they don't, after that 30 days has expired or the appeal comes back and the court affirms that, meaning they agree with the commission, then it also becomes an open record at the end of those 30 days.
And which includes the name of the complainant?
No. So when the complainant chooses to remain confidential, their identity always will remain a confidential record under the statute. If they choose to make their name known to the respondent, then their name would also become an open record. Any other questions? It's a lot.
But the way it works now, with the legislative changes, the respondent can speak to the complaint or no?
Yes, the respondent can speak, with, assuming that
You just can't reveal the complainant. That would stay confidential if the complainant elected to be that way.
Yes.
But
Yes,
the
but the
respondent can address the complaint.
And the respondent wouldn't know the complainant's identity.
Well, he would know, or he or she would not know either.
They wouldn't know in that instance, so there'd be nothing for them to reveal.
But what if the respondent would, I know who did it. It's so-and-so. That's their choice, right? They can say that. They're not prevented from saying that.
No, they can allege it's whoever, if they think, if that's their belief, they're free to
They
allege
can allege
that
that if they want, yeah.
And there are some instances where they may know. If that's the case, we may need to go back and look at the complainant waived the confidentiality. That may or may not be the case, but
We've had cases where that has happened. Right?
where
Or where we
a respondent
evaluated.
believes they know, they're like, well, I know who it is. And we're like, well, can you provide us information on how you know so we can evaluate whether the complainant waived the confidentiality?
Oh, because if they, after they made the complaint, if they spoke to the respondent, then they kind of waived their,
If they said, I filed this complaint against you, even though I'm confidential, that would be an instance
that would
where
be
they
an
waived.
yeah.
Yeah.
Okay.
I have a question. Now, after it's signed, is there 30 days to appeal? And the appeal is on the record, and the record would include the report and all underlying documents?
Yes, well, we certify the record, so to speak, when, based on the stipulation that that's the record they've received as the investigation file. So that, yes, that is the record. And then in the report, where it references things in footnotes, that's all going to be contained in the investigation file itself. That's the underlying documents that form the basis for the report.
So it'd be handled as a traditional administrative record.
I believe so.
It would probably have to be filed under seal, right?
Yeah. But that, again, that's the
Again, that's-
respondent who has to figure out how to
Yes.
take it to court. Commission wouldn't be the one appealing. Since it's the decision maker. Any more questions, or you want to do the mock hearing? Ready for it? I'll go over the document. Can you bring it up, Alicia? Attachment 12. So this won't be part of a complaint record. This is a document to give direction to the commission for how to conduct hearings that we as staff put together. Again, you need a quorum. I'll just go through this briefly. The hearing overview, this is, again, similar to what's in that stipulation that the respondent is given. But for the commission to be aware, in most instances when we go into executive session, we announce who's in the executive session, including staff. When we do these hearings, we can't do that because it reveals confidential information that these people are now joining us. Well, that's related to an investigation.
So the hearing, executive session include complainant and respondent?
No, so you would
Just
go in,
respondent.
you would go into executive,
Yeah.
yes, it would include just the respondent, and you go into executive session the same way you currently do by just announcing the complaint numbers.
Yep.
And then say, the commissioners are there. You really don't even need to say staff is there under the statute, even though we do that practice. You can continue to do that. Just don't say the respondent will be joining us or so-and-so witness will be joining us. Just close the meeting the same way. So then the chair's designee runs the hearing, just like you do the meetings. You determine the order of presentations. Again, there's the default 30, 45, and then 15 for rebuttal. So then we put in here, and the blue is kind of like a script for the chair or the hearing officer, the chair's designee. So you announce the complaint and start the proceeding. Saying those words, fill in the blank type situation. Executive director begins the presentation. Let the executive director begin or continue the presentation, or the executive director's designee, whoever it is. Then when the executive director is done, again, say the blue, respondent presents. And the executive director, again, say the blue, comes up for rebuttal if needed. And then you essentially finish and close the hearing, adjourn, and then the commissioners participating in the hearing, let's say it's on Teams, you'll have a separate link to deliberate amongst the five of you without anybody else in the room, so to speak. Like if we're in a physical room, everybody will just leave. It'll just be the five of you. But you do have to record your deliberations because it's part of the executive session. So then, again, some guidance for deliberations. Consider the entire record, the report and recommendation, and any response provided by the respondent. Again, the proposed order is there for you to work off of, and then the commission makes that final determination, whether there's an ethical violation or not. Some additional information on how to make the motion. The five of you are well aware of how you make motions coming out of the executive session. You move that the chair or the chair's designee take the action as discussed in the executive session on the complaint numbers. You have that the substantive discussion before you make the generic motion on the record. And usually that'll be to direct the chair to sign the proposed order or an order with edits or whatever order you come away with from your deliberations. And then we have the last thing on there is evidentiary and procedural issues. Again, this is in the commission's rules that the commission is not bound by the rules of evidence or procedures, so they do not have to be well versed in evidence or procedure law to conduct the hearing as the chair, but effect is given to the rules of privilege if they apply. I don't believe that will come up very often during a hearing unless there's a witness potentially. What's not on here currently is how to handle witnesses, so we'll add that to the document. We're just having some internal discussions on what that should look like, and we'll discuss that with you, Dave, but that's kind of the overview of how a hearing would work.
So I have a question. Can the commissioners during the hearing ask questions of myself as the executive director or of the respondent or his or her attorney?
I believe I
During
have that
executive session?
Mm-hmm.
Okay.
in here somewhere. I don't
You do.
remember where it is. Yes, at any time, commissioners can interrupt to ask questions. So if any of you have watched the Supreme Court do oral arguments, they interrupt regularly. You can ask questions anytime, just like that, or a legislative hearing, when they interrupt to ask questions, you can do that as well as commissioners. If there's a road you want to go down or if you have questions about something specific, feel free to speak up and ask them.
So in this instance, basically, if I were the executive director on this one, on this complaint, I would walk the commission through.
Well, why don't we run through it?
Do we want to do it?
Yeah, why don't we run through it?
Okay.
Do it that way.
I wasn't really prepared to
Go ahead.
sure, make my presentation or my argument, but
I think we should just for practice.
okay. So what I would say with our fake complaint,
The chair started thinking.
Oh, yeah.
So we do go into executive session, we review script essentially. And then you start from the procedure over, you read the. Let them pretend that you did.
Kind of idea.
And then,
I know where it is. Do you know where it is?
I lost my sheet. Oh, there we go. Okay.
The commission has before it complaint numbers 825549997 for a final hearing. The matter of Clem Cadiddlehopper, Farmer. Commissioners present are Ward Kozer, Murray Sagsby, Dave Anderson, Cindy Lindquist, Ron. Appearing on behalf of the executive director are Executive Director Rebecca Binstock and other commission staff assisting the presentation. Appearing on behalf of the respondent are George and Gracie, George Allen and his attorney Gracie Allen. Time allotted is as follows. Executive Director presentation, 30 minutes, rebuttal 15 minutes. Respondent presentation, 45 minutes. At this time, the executive director may begin her presentation. She just left. So we'll wait until she comes back. Or the designee may begin the presentation.
so I don't know in most instances if she'll want to do it herself or if she'll want staff to do it, or if there's a SAG that's assigned or an investigator who's assigned to do it, but I'll just pretend for the sake of.
Well, she likes the limelight.
For the sake of pretending, what will happen is usually, her or I or whoever it is will say, you have the report and recommendation before you, we submit it, et cetera, on its merits for your consideration and recommend the commission adopt the proposed order as outlined in the report and recommendation. So I don't envision most instances where we'll present a case for 30 minutes. It'll be the report and recommendation that the commission will rely on, unless the executive director has differing thoughts. But I was just saying, in most instances, I don't think the 30 minutes will use, but we'll submit it on the report recommendation. Suggest that they adopt the proposed order as outlined in the report recommendation, then just take questions.
That's correct.
Okay.
Sorry, I apologize for the phone call interruption.
Well, we dismissed the case since you weren't here.
Oh, okay, well, that makes sense. But I think what I would probably do is give a little bit of a factual background, but the commission is all going to be, they've read it before.
Yes.
Do you want me to do that now?
Go ahead, do what you would do.
Dave's shaking his head no. This is a great fact pattern though,
It is good.
great fact pattern.
It's good.
But because you had, in this instance though, you have a whistleblower coming forward, right? So you have somebody who made information public, and this is the administration of a bill, Bill 1000, I love the number. And you have this potential or this criminal overlay in this one. So this also demonstrates how the Ethics Commission can receive a complaint by an individual who may not have firsthand knowledge, right? Because this was originally posted, the whistleblower posted it on a blog, and then the Ethics Commission received a complaint from that. So what I would do is probably just submit this to the commission. There would be an instance though if there's a response, right?
Yeah.
Where the respondent has submitted a response, I might have something to address that.
So that may come up, but then the respondent does his or her presentation, and then there's a chance for rebuttal, which may be that
Yes.
instance that you just spoke of. But then at the end, you close the hearing and go into deliberation. There's one more thing that I want to note with this, and I think we get this question somewhat often, but if there's a criminal issue that comes up, let's say that there is a conviction, how does the commission handle that when it comes back?
Previous conviction or conviction as a result of the
Of the
investigation?
referral, of the referral.
Okay.
So that's what this found
Okay,
took into effect.
He
So-
was charged and pled guilty to bribery and trading in special influence.
So that's the fact pattern we came up with. So how does the commission handle criminal allegations if they relate to transparency, corruption, elections, and lobbying? Well, you can take notice of what the criminal court did. Let's say that there is a judgment that somebody violated a criminal law. When it comes back to you, does that criminal law relate to corruption? In this instance, bribery relates to corruption. So just take notice of the fact that the court proceedings went as they were supposed to. There was in this case, a guilty plea to that bribery statute that relates to corruption. So we can define that as an ethical violation. That makes sense.
The commission can.
Yes.
I also want to point out that the question that Marie presented us with earlier, when the commission learns about a potential ethical violation in the context of an investigation, what do we do with it? This would be an instance of that happening here with the fact pattern that's presented, because Elmer Pine has an interest in a company, and then he voted on legislation that he knew would benefit that company, right? So, but that wasn't the original complaint. The original complaint was against, I forget his name now, Spruce Oak Ridge. So,
Nobody else would have that information.
I mean, potentially, but nobody else is nearly as aware of it as the Ethics Commission would be. We did not do that intentionally, by the way. That just is a consequence.
Okay, so, Spruce Oak Ridge has gone through the criminal process already. Now it comes before us, we find an ethical violation. His position, what's his position in here? I can't remember.
He's
a
the,
legislator?
nope, he's not the legislator.
Director of the Department of Forest Creation.
Yeah.
Okay, so that's a state position. Okay. So then we make a decision, if we find him guilty, or, I don't know the word we want to use.
Find that he,
Finding engaged in an ethical violation.
Right, then we can just say, decide what we're going to do to him as a result of his position in state government?
Yes and no. If there is a penalty that is in the law, authorized by the law for the violation, yes. If there's no penalty assigned to a violation, then no, it's the finding that he violated the law is the penalty.
Okay, but that's already been determined by a criminal court.
Well, that's the criminal
That's the
violation.
criminal violation. You are now taking notice of it as an ethical violation as well.
Okay,
But he had other ethical violations. Spruce Oak Ridge also failed to disclose a potential conflict of interest before he was advocating for Bill 1000 in his capacity as the director of the Department of Forest Creation. And then he also engaged in an ethical violation by failing to disclose a potential conflict of interest before or while he was administering the Forest Creation Program. So those aren't criminal violations necessarily, those are ethical violations.
okay.
So, and then we took notice of the plea agreement.
Okay, so where do we go from here then? Where do we go from here?
Where does the commission go?
Yeah,
So like Logan said, if there's a penalty that's associated with the violation, then the commission can assess that penalty. If there isn't, so the conflict of interest rules don't have a penalty associated with them, it's going to be, the penalty is going to be the finding that they violated that conflict of interest rule or law, yes. So I think I do have a question though, is that something that we can then refer to their superior or their?
Yeah, well, it's anytime a report becomes public, if you believe there's somebody they need to be accountable to, whether that's, let's say it's another commission, whether it's the commission as a whole or the appointing authority, whether it's the governor, whoever it is, you can take the public document once it becomes an open record and give it to them. There's nothing that prevents the commission from doing that. Here's what we found, just so you're aware. Maybe you need to look into this as so-and-so superior.
They may have internal processes and procedures for how they handle misconduct or something.
you know, this seems to me to be a fairly weak response to his actions. Am I right or not?
The fake response to the fake actions?
Yeah.
Okay.
So that's a question for the commission. If there's a rule that the commission created that's violated, when you go through the rulemaking process, does there need to be a penalty associated with that? Or maybe just at large, does there need to be a penalty that applies to all ethical violations? That's really on the front end with the rulemaking authority of the commission rather than on the back end.
Okay.
Because you can't really write in something that's not in the law.
Okay, I think we should make him walk on the hot pavement during the summer.
Barefoot.
Barefoot, yes. Okay.
Can the commission prescribe education as a
If
result
there's a
of?
rule that aligns with a violation, yes.
You could do it as part of a settlement agreement.
You can definitely, yes, definitely do it as part of a settlement agreement.
No, I'm just concerned that if he or she, most likely it would be a she.
Notice how Cindy and I looked at each other.
Excuse me. Would be satisfied with the criminal complaint and would think of the ethics consequence as incidental. I don't know if I'm getting that right or not.
It's possible.
Yes, that applies in the context if there is a criminal component to it. A
Yeah,
large majority, there's never going, this was just for the purposes of demonstrating how
Right,
that works when
right.
the commission receives it back.
right.
In most instances, there may be let's use gift violation, for example. There may be a gift violation, but it's not criminal. There still should be a finding that an ethical violation occurred.
Right.
Yeah. Or if there is a criminal component and the state's attorney or the attorney general, depending on who has jurisdiction, decides not to prosecute.
Yeah.
Right?
So we should make sure that consequences that we put in place have some teeth.
If you want to make a consequence, it should be in the rule, yes.
Yeah.
And make it consequential.
And I didn't mean that about when.
We know.
We know, we have the data.
Yeah.
We'll whip out the data to show you that, never mind.
Yeah.
Yeah, well, the other point though is how do we not downplay ethical violation? We're the Ethics Commission. And there's aspects of this where I want to shout it. I want him to walk around with a red letter.
Yeah. Like some
Yeah.
recent cases in North Dakota that we may not have handled.
Yeah.
So,
So part of it, once the complaint process is over, you have that file, like this file, you have the file, so there's nothing that prevents the commission from discussing it further in a public meeting, etc. I don't know what that would necessarily look like, but you can have further discussions about what occurred, whether there's some recourse that needs to take place on the front end with rulemaking processes, etc. Maybe education stuff, I don't know.
Maybe.
But
The other thing is that once the appeal process is done, then the confidentiality veil goes away. And it is public then. Yep. So it's, we envision where once the commission issues a finding or an order that it will, and it's either not appealed or the appeal is affirmed or something, that it will then go up on the website. So that finding will be accessible.
But let's put it.
I'm not saying that that's maybe what
But
you're
let's
getting
put it
to,
up
but
there with the yellow highlight or the red highlight or whatever. I mean, and again, well, never mind.
In effect, it's treated like an open records
yes.
under existing.
With the conflict of interest, right? Because there are other, like the gifting rules is 2 times the value of the gift. And that's when we talk about the travel, right? That there's that penalty, civil penalty that is attached to the travel rules as well. So the question I think as Logan phrased it is, should there be a consequential penalty attached to this particular violation or all violations where we have a general rule about penalties that could be assessed by the commission?
I have no further questions or comments.
Okay, thanks. That was a lot of work that you put into that, but I think it's very helpful, going from beginning to end that way and having all those details is outstanding. I mean, that's perfect.
Thank you, Chat GPT.
Yeah.
And Logan legal analysis.
Yeah.
Our Logan GPT.
And uploading that into ChatGPT, so ChatGPT could put something out. I assume that's how that works?
I had to give it very detailed criteria, because some of it was just like, that was not workable, but we got there.
But the other thing is, this is going to be good for, as the commission goes into hearings, keeping this as a reference material will be really helpful to prepare for those hearings.
Yes.
And then we do have the issue, just one more note, we do have the issue of witnesses. If somebody wants to bring a witness to testify before the commission, how will we effectuate that? How will we do that? That is one thing that we have not nailed down yet, but we have
They
a good
to bring 'em
sense for
into
it.
executive session, right?
Yes, it would have to be an executive session.
Would he be present? Okay, well, thanks for that. That's amazing. I'll have to learn ChatGPT eventually. No, I won't.
Did the interview summary, so if you're interested.
I'm not gonna do that.
The interview summaries are interesting too.